Hey there, today it's all about real stories from the courtroom, my most memorable cases. And when I talk about my most memorable cases, it can get really, really hard because my mind just floods with all of the things that have me going, oh my gosh, I can't really believe that just happened. But some of them really do leave a lasting impression. Today, we're going to open up my case files and share some of the most incredible things that really taught me how to be an attorney and how to better prepare for my cases in court because I learn lessons too. That's why they call it the practice of law, right? We learn as we go. So some of them super high stakes. Some of these cases ended up causing my client to lose because of what they did. And it really, really turned their cases around. So if you know these things, then maybe it will help you prevent them in the future because just like it happened to me, I learned from them. Maybe you can too. Welcome to Gavels Down, Voices Up with me, Rachel King. This is where we leave convention at the courtroom door and dive into your real stories, bold and unpopular opinions, and change-making ideas that really shake the legal world up and change where change is desperately needed. I'm here to shake it up, talk about unfiltered insights, and amplify voices that need to be heard. So are you ready? Let's get it. Put the gavels down and the voices up. So today we're going to do a deep dive into the heart of my litigated cases and some of the things that had me going, WTF just happened, where the law and life intersected in the most dramatic ways. So let's go as we explore real life cases that challenged not just my clients, but me, and often have the judge saying, oh my gosh. And it's hard to have judges say, oh my gosh, especially when you're in family law. Let's take a step back and look at the role of the courtroom, right? You can reach an agreement on any single thing that you want, but we find ourselves going into court when there is something happening that cannot be resolved outside of the court. So that at that point, we're looking at what happened and the laws, and we're saying, here, judge, here, court, you decide. And that's really where some of the most impressive things happen. Why? Because we get them oftentimes on not tape, but recorded, right? The court reporter, we can actually go back in and see it in writing what happened. So I went back and I thought, what are some of the most amazing cases that taught me something and that can hopefully teach everybody that is listening or watching this today? All right, my most memorable cases. Number one, there once was a husband and a wife who had been married for 50 some odd years. Such a long marriage. They got married at like 18 years old. Everything that they had was community property. At some point, as they got older, dad started having some health issues. Mom was showing signs of early onset dementia, but nothing had been put in writing. Child number one came along and said, Mom, Dad, I think I can help you by saving probate so that your assets won't go to the state and instead will go to all of the people that you want. Mom and Dad were like, yeah, this sounds like a really great idea. It's important to note for this story that Mom and Dad were not native US citizens and English was not their native language, though they'd been here for, 30 some odd years. And they did, at this point in time, speak fluent English, but their reading, I'm not so sure about. Anyway, by the time it gets to me, the house, the one major asset that Mom and Dad have, is no longer in Dad's name and it's no longer in Mom's name or husband and wife. It's in child number one's name. And actually, both husband and wife, Mom and Dad, came to me and said, I don't like this. I don't know how this happened, but this is not what we wanted. So we talked about some different things. Ultimately, we ended up filing a lawsuit to correct the title on the house. During that time, husband died and mom or wife's dementia got far worse. Right as we are filing, right after we filed the lawsuit to correct the name on the house, mom gets a notice of eviction. So picture this. Mom, who's got dementia, just lost her spouse of 50 some odd years, has no income, hasn't worked her entire life because she's been married and that was the marital decisions, is now being evicted from her house, the one house that she and her husband had successfully paid off and was supposed to be the basis of her retirement. Blew my mind. Now, ultimately, all is well. Everything got sorted. Mom got her house back. But the nail in the coffin on this case, the clinch pin, whatever you want to call it, was when Mom got the eviction notice from daughter, child number one. That was what threw this entire case and basically made it for wife/mom. Why? Because child's whole entire argument was, I was doing it to avoid probate. This is what my parents wanted. They wanted me to have it. Keep in mind, this was not only one child of the relationship situation, right? There was more siblings. But the entire argument, child's entire argument was sunk the second that she served an eviction notice on mom. Why? Because you can't say you were looking out for mom's best interest or this is what mom and dad wanted when you're kicking mom out of her only place to live. That wasn't just my opinion as an attorney on this case. That actually ended up being the judge's opinion as well. We got it fixed and corrected, but my goodness, this poor woman had to go through a legal battle all while she's negotiating dementia. It was just a travesty. And to me, it was one of the most memorable cases I had because I couldn't believe that somebody would actually try and evict their very elderly mother, especially after having created estate plan documents or deed documents that gave them the house. Without that clinch pin eviction, I don't know how it would have gone, but it would have been a harder case to win. So that was one of my most memorable, probably because it was shocking, but also because we had a wonderful outcome, though it was long. All right, my second most memorable case. Oh, this one needs a drink. I don't drink alcohol, but we'll stick with my Snapple. Maybe one day Snapple will sponsor me. I'm not nearly famous enough for that. I don't even think I'm famous, but Snapple, shout out, send me some cases. Okay, the next one. I represented wife and husband was the other party. We were going through a divorce case where wife was accusing husband of alcohol and drug use. Serious drug use. And whether these allegations were true or not, I don't ever know the truth. I figure there's two sides to every story. I had an attorney once that said, no, there's two truths in every case, and you're just making your case based on your client's truth. Truth, that's a very nice way to say it. I think sometimes people just lie. Anyway, the allegations that my client was making was that there was a pretty big drug problem. So we file all of the paperwork to get custody to my client based on drugs, and we get vehement denial. This is absolutely ludicrous. There's no drug use. Everything is being made up. Your client's a liar, blah, 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 blah. I was like, all right, cool. But then I get this really interesting email from my client that says, oh my gosh, my ex is buying hair shampoos and drug detox kits off of Amazon. Here is all of the proof. Here's what happened. Other party didn't want to pay for their own Amazon Prime account to get fast shipping. So they had stayed on a joint Amazon account. They had a joint Amazon account during marriage through this very, very troublesome and contentious divorce process. They'd maintained a joint Amazon account because they didn't want to pay the subscription fee for two of them. Other parent, knowing that there was all of these drug allegations and volunteering to take a drug test, went onto the joint Amazon account and decided to buy shampoo and drug detox kits. I don't know, in maybe an effort to pass the drug test, they'd volunteered to take it. Here's the thing. I don't actually know if those drug kits work. I'm not here to it, but it was pretty compelling when I got to walk into court and say, Your Honor, I really do think that the kids need to stay with my client. I think there's really serious concerns of other parents' drug use, especially given that on the Amazon invoice transaction history, it shows that other parent is buying hair detox kits and drug kits. That's the title of the purchase, the product name, and it's being shipped to other parents' address. The court agreed in that case. I still don't know for real whether the other parent was using drugs or not, because we kind of sidestepped that whole issue with this big finding. But I thought that was interesting because, man, you don't like your ex. You're going through a contested custody battle or a divorce process. Split off of all of the joint accounts. If it's Amazon, if it's eBay, if it's OfferUp, I don't know, wherever you're buying your things from, get your own account as soon as you start getting divorced, because it could be used against you. Another very interesting case that also had me going. A lot of this one also has to do with substance abuse. My client was being accused of having a drinking problem, and other parent was using these accusations as a way, which often occurs, whether it's legit or not legit, to get more custody, right? Take away custody from my client because of these huge allegations of alcohol use. In this particular case, my client didn't have any DUIs. There was no documented abuse of alcohol, but other parent was really relying on the fact that they'd been in this relationship, they'd witnessed it for such a long time, and that was the basis for saying that there was an alcohol problem, also saying that other parent didn't feel safe leaving the kids alone when they were married and all of these things. And therefore, because of the personal knowledge, the court should accept that there was an alcohol issue. Of course, as the attorney, I came in and said, this is nonsense. There's no DUIs. There's no alcohol history. There's nothing. This is just other parent trying to manipulate the system. We had a court hearing, I think on a Wednesday, and the court said, we're coming up on a holiday weekend. I'm going to table this and come back the next day. I think the court was running late. So they had us come back the following Friday, right? The holiday weekend was coming up. I got off the phone, or we finished the court hearing. I called my client and I said, all right, I don't care whether there is actual alcohol misuse or not, but what I'm telling you is over the holiday weekend, no alcohol whatsoever. Please make it through this holiday. And it was a holiday that was known for alcohol use. Please make it through this holiday with no alcohol. Just mind your P's and Q's until we get back here on Friday, because I don't think other parent actually has any evidence to support this. We go out for the holiday. I come into the office after the holiday weekend to a message from another attorney, other parent's attorney, that says, hey, just following up because it came to my attention that your client got a DUI over the holiday weekend with the children in the back of the car. Is there a worse message to get as an attorney? Probably not. Other than wanting to pick up the phone and strangle my client's neck and say, what were you thinking? I specifically said no alcohol this weekend and you assured me. That was not the case. Ultimately, in that case, my client lost and I got to walk into the court, tail between my legs, and say, I don't know. My client doesn't know. My client's pending the criminal hearing and hopefully will be found not guilty, and all of the things, trying to take the rough edges away from the incident that actually occurred, but not great. And I just thought, you know what? Whether or not my client had an actual substance abuse problem, this was really poor timing to get a DUI, especially with the kids in the car. In that case, other parent got at least temporary custody of the kids. I wasn't involved in that case for too much longer, but sometimes just follow the advice of your attorney, because timing matters and you never actually know what is going to happen.
And now for a quick break. This episode of Gavels Down, Voices Up is proudly brought to you by King Law Firm Attorneys at Law Incorporated. We're not just about winning cases, we're about making a difference. Whether it's family law, probate litigation, or standing up against elder abuse, we bring experience, empathy, and excellence to the courtroom. At King Law Firm, we're more than lawyers. We're your team, in your corner, advocating for your rights and making your voice heard. Visit us at thelawyerking.com and on the socials at The Lawyer King to see how we fight with you and for you. King Law Firm Attorneys at Law Incorporated, where your fight becomes our fight. Now, let's get back to today's episode.
The next ones are like a clump of my most infamous cases. They're infamous to me because they are very personal. It's all of the times that my clients have lied to me. So that's my last one, is all of the times that my clients have lied to me. And it has ultimately ended up screwing them because I didn't know what was going on. So collectively, as an attorney, you would think that everything that was told to me would be truthful because it's confidential, but that's simply not the case. And in these few that I'm about to talk about, the lie ended up really affecting negatively my client's case. One, because I didn't know it was a lie. Two, I didn't know what the truth was, so I was unable to effectively prepare for the truth. And so it kind of blindsided me in the courthouse. I was doing a divorce case and there was a bunch of assets that were in dispute. It was a pretty successful couple and we had cash in the safe, we had money in bank accounts, and we had a lot of very valuable, tangible personal property. Think RVs, boats, motorhomes, collectible cars, things like that, jewelry, Rolexes. We had a lot of the stuff. My client said, it's all been divided. That money that was in the safe doesn't exist. It never existed. The money in the bank account, there was a list of assets that my client said, no, they don't exist. We got rid of them during the marriage. I definitely don't have them. And I said, okay, I just need to know. Like, if you've got them, you've got them. We don't want to get into a situation where we are hiding assets. Why? Because I've seen courts say if you hide the asset, it goes 100% to the other person. And I've watched courts actually order that. So I said, let's not do that. Just like be upfront with me. No, Rachel. They don't exist. They don't exist. They don't exist. All right. So I'm going to walk into these court hearings. I'm going to walk into this trial. I'm going to walk into this mediation. And that's going to be my position because I don't know. And I walk in and I get presented the statements from the storage unit, photographs of the storage unit, letters written by my client and signed, all that say, please hold on to all of my stuff and don't tell anybody where it is, but give it back to me when my divorce proceeding is over. Oh my gosh. I don't even know how the other party found all of this, but I looked at my client. I said, this is your signature. You wrote this. What is going on? Oh yeah, I was just doing it because I basically, it was just a loan. I said, how can it be a loan when you're asking for it back? It really seems that you were having this other person hide it for you so that the court didn't know about it and it wasn't disclosed. And now it is. And what are we going to do? And in that case, the court actually decided that yes, my client did intentionally withhold the disclosure of a certain amount of assets and ordered 100% of them to the other person. So not only did my client not successfully get to lie, he also didn't successfully keep half that would have been kept if it had been disclosed, because you're entitled to half of the community property assets, but actually awarded 100% to the other spouse and attorney's fees and costs for having lied, sanctions. Oh my gosh, what a nightmare. And quite frankly, can I just be honest, super embarrassing for me, because when you're sitting there, it's kind of like everybody knows that your client just lied to you. And now before you all come at me and say, well, don't you double check what your clients tell you? No. Why? And first of all, how am I going to do that? Go and find some special place on the, black web that gives a list of what everybody owns? Not my job. My job is to ask my clients and have my clients be forthcoming. In this case, client wasn't forthcoming and lost their ass. Don't do that. Don't do that at all. The other time that I've seen clients, or that I've had clients lie to me, is where they tell me that they've never seen it. So I had one case where there was this document that was signed by my client. It was a typed document and then it was signed with my client's signature. And I said, did you sign this? What's going on? It's not great if you did, but we can work with it. No, it's not me. I was like, okay. We're going to get handwriting experts. We're going to do the whole nine. We find a handwriting expert that isn't willing to say that my client didn't sign it, but is willing to at least identify on the stand where there would be some inconsistencies, hopefully so that the court can come in and say, maybe my client didn't sign it, maybe this is fraud. That's kind of what we wanted to. That was the angle we were going with this. Pay the expert to appear in court. My client gets called to the stand first. Before I can bring on any experts for testimony, my client gets called onto the stand. I think a year and a half into the case, since I've been on it, lots and lots of money, a whole lot of trial prep. The first thing the opposing attorney does is hand my client the document, asks my client to review it. My client reviews it, asks my client if my client's ever seen it before. My client says yes. And then the attorney, I think just for kicks, because I don't think the attorney was expecting the response that was given, because we'd put the expert, we'd disclose the expert, handwriting expert in our witness testimony. It makes me laugh just to think about it. The other attorney says, did you sign this? I kid you not. Without skipping a beat, my client says, yes, that's my signature. Oh my gosh, what are we doing here? Our entire case just fell apart. You spent all of this money on an expert and now you, panicked? It's like, okay, great, because you're under oath, you should be telling the truth. But like, at what point, why did that cause you to gain a conscience? My mouth literally dropped. There was a noticeable pause from opposing counsel when he was like, did this really just happen? I, of course, asked for a recess. I tried to rehabilitate, but the bottom line is that my client had signed it. Somehow, shockingly, my client remembered as they were sitting on the stand under oath, swearing to God they would tell the truth, the whole truth, and nothing but the truth, that they had actually signed the document. Anyway, it wasn't the end of the world for the case, but we didn't win. We just kind of walked away with a tail between our legs and conceding many of the issues. Not great. Tell your attorney the truth, because truly, what a mess, waste of time, the whole thing. And the last most memorable cases, again, this is a grouping, and this is when people make up garbage in court to try and gain some kind of strategic advantage. I see this a lot when it comes to child custody and visitation, probably more than any other area or kind of case that I've ever dealt with, even more than as a divorce case when we're dealing with assets, is the lies that people make up to the court to gain some kind of strategic advantage when it comes specifically to their custody and visitation arrangement. Of course, we've all seen the domestic violence restraining orders. I'm not going to say that they're an outright lie. However, I have seen that the version of the truth that's used in court to get a temporary domestic violence restraining order that would ultimately gain some kind of advantage in custody and visitation are really far on the spectrum of what would be their version of the truth or the actual truth. So call it a lie, call it their version of the truth, I don't care. But domestic violence restraining orders are one that's a real kicker for people stretching the truth to gain a strategic advantage in family law. But one time I read paperwork where the other party filed a domestic violence restraining order, and it was granted on a temporary basis. I still sometimes wonder if the judge even read what was written, because what was written is something like this. Going through a divorce, custody and visitation is at issue. The declaration in support of the domestic violence restraining order said, generally, I had a dream that other parents abused our child, and I believe after waking up from that dream that our child is going to be abused, and that was a foreshadowing dream. Somehow the court granted a temporary domestic violence restraining order based on a dreamlike scenario. There was no history of abuse. There was no allegation. Nothing. Fortunately, in that case, when we got to permanent restraining order, because who's going to submit to that or try and negotiate it? Every time it was brought to my attention that there was some kind of negotiation, I was like, we're not negotiating custody based on a dream that you had. If we did that, I would have divorced my husband like 100 times, because I had dreams while I was pregnant that he cheated on me all of the time. I feel like that's a very common pregnancy dream. I don't know, maybe because we're all insecure, but dreams, get out of here. Fortunately, when we got to the permanent restraining order hearing, the court agreed, after looking at it more closely that a dream is not a correct fear of domestic violence, and so the court denied it. But for that entire time, from the time that it was granted temporarily all the way until we got to formal trial, kids were not with the alleged abuser because the temporary was granted. Talk about adding upheaval to a case. So that was one of the most shocking things I've ever seen when it comes to the lies that people make up to gain some kind of strategic advantage. The other one is that also just jaw dropped. Like my jaw dropped when this happened. Was my client was winning. Other parent was kind of a mess, had substance abuse issues, some mental health issues, really was not a functional parent. To some degree admitted that they were not a functional parent. So we went in really not to cause a whole lot of aggravation, just to make sure that through the split, the child had a safe, stable environment with my client and some kind of appropriate visitation with other parent, not even supervisor, just a basic visitation schedule. My client, I will give it to my client, did not want to remove other parent from the children's lives, just wanted to get a safe agreement. We put all of our evidence up. Other parent walked in and lied about not having a substance abuse problem, not having a mental health issue, not having all of these things. We did have the supporting evidence. The court confirmed everything that we were saying. The court was making the order granting my client sole physical custody, joint legal custody to other parent. And right in the middle, with reasonable visitation, there was some visitation. We hadn't totally gotten to the visitation part, because right in the middle of the court making that order, which is never when you interrupt, other parent says, one of our kids came home and told me that my client had touched them sexually. Mic drop. If there is ever allegations of a parent potentially touching a child sexually or sexual misconduct, the court has no choice but to stop what they're doing and investigate it. No matter what. It was so obvious that the other parent was just trying to throw anything that stuck to the wall so that they wouldn't lose physical custody, or I don't even know what they were doing. They're just irrational. So they threw out that little tidbit. And the court, in the middle of making the order, stopped, looked at me and said, Ms. King, you know, with allegations like that, what I have to do, I have to take them seriously and I have to have them investigated. And I said, yeah, I mean, I think I gave all the reasons why I think the court shouldn't have to do that. But ultimately, the court said on a temporary basis, I'm granting other parent sole legal, sole physical custody while my client, good parent, is investigated for these allegations. Fast forward, of course, the allegations were unfounded. Everything that we said about other parent was confirmed. But during that time, the children were with other parent who was a mess, sleeping out on the patio, saying that there was voices in other parents' head, peeing on themselves because they drank too much or were too intoxicated or under the influence of something to even get to the toilet. I mean, really bad things. The kids were subjected to that for a short period of time, but for a period of time, all because there was one quick allegation of sexual misconduct that ultimately was unfounded. Travesty to the case. But it's what people do sometimes to gain a legal advantage. I don't know that actually doing any of this is a good idea from the case. Every single time of every single example that I've given today that really made it to my top list was bad things that people did that ended up screwing their case. So the takeaway is tell your attorney the truth, be careful what you say, and really you're in court to have the court make some pretty big decisions. So watching your credibility, maintaining your credibility and being honest and truthful, pretty good idea. All right, that's what we got for today. And I'll tell you, if you have a fantastic story about something that you saw that happened in court, I'd love to hear it because these are fascinating to me. And sometimes we really hear the best. Go read it on Reddit or one of those websites and laugh. It might cause you to laugh and think that your case isn't so bad. I'm Rachel King, and this is Gavels Down, Voices Up.
Thanks for tuning in to Gavels Down, Voices Up. Like what you heard? Then don't just sit there. Subscribe, share, and tell me your thoughts. I'm Rachel King, bringing not just my opinions to the mic, but about the courtroom too. Your part, keep listening, keep engaging, and until next time, let's keep those gavels down and our voices up. Unmistakably up.